Williams, come on up.
Good morning, Mr. Williams. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 25th, 2025, an officer was dispatched to Montrose Boulevard for a call for service related to driving while intoxicated. The officers observed the defendant's motor vehicle upon arrival. The officers observed the defendant's vehicle to have major front end damage, multiple airbags reported, and to be leaking fluid. The officer met with the witness who called 911. The witness stated he observed the defendant's vehicle to have struck a light pole. The witness stated that he did not see the actual crash, but saw the defendant back up and start driving away from the crash scene. The witness observed the defendant drive several hundred feet before stopping due to the motor vehicle being disabled. The witness stated that they observed, the officer made contact with the defendant and an officer observed a strong odor of alcohol.
Notice how the judge highlights this isn't just a regular DWI. It's a Class A misdemeanor because of the high blow. That means the blood alcohol content was way above the legal limit. Audience question: do you think penalties should be harsher when there's property damage involved, like in this case?
Beverages emitting from the defendant's person. The officer also observed the defendant had bloodshot eyes and slurred speech. The officer observed the defendant had trouble maintaining balance as well. The defendant consented to standardized field sobriety test. The officer observed 6 out of 6 clues on the HGN test, 7 out of 8 on the walk and turn, and 4 out of 4 on the one leg stand. Defendant consented to a breath sample, and which the test readings came back at 0.185 and 0.168.
Any prior DWIs? And then does he have a license?
No prior DWIs, Your Honor, and I'm running that license.
Please. Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail.
His license is eligible. No.
As long as you have a valid license and liability insurance in your name, then you may continue to drive. But if I find that you're using, it's not going to go well, and I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire a lawyer, sir? Okay, we will give you time to hire a lawyer. So I will first have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions. After that, we'll get you out here to hire a lawyer. All right? Please.
That's good.
Good morning, Ms. Woods. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 26, 2025, in Harris County, Texas, officer was dispatched to a disturbance call. Officer met with the complaining witness.
Despite crashing, smelling of alcohol, slurred speech, and failing multiple sobriety tests, the defendant still gets bond with conditions: no drinking, no drugs, random testing. This is the legal system's balancing act. Accountability versus giving someone a chance. Would you feel safe knowing he can still drive if insured?
Stated that he and the defendant were in a sexual relationship. The witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complaining witness in the face, head, causing pain. The defendant also ripped the complaining witness's shirt, scratching him in the process, also causing pain. Officer observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want
He
to.
does not.
Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? You have the ability to hire a lawyer. We can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive. And then I'll take a look to see whether you qualify. I'll have you sign a receipt with Victoria. We'll give you the application, then we'll have you take your seat in the jury box. Thanks.
This way.
And they're dismissing the felony upstairs and he's
Change for
doing,
this?
yes, for the probation with TRAS conditions.
Has a TRAS been done yet?
Yes, and the recommended IOP is okay.
Salustria.
No, shh. You have, or you're not you, but your lawyers have worked a killer deal for you today. You speak English, right?
Yes, I do.
Where they're going to dismiss the felony in exchange for your plea on this case. I'm going to tell you now, this is not something that happens very often. So get a clue. Do you understand?
Yes.
The agreement that you have worked out here is you're now charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have is 180 days in jail to be probated for 15 months. You need to understand that this charge is going to go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Not only that, whenever you get pulled over, officers, the first thing they do, and the only thing they do when you get pulled over is they look at your record. If they see that you have a prior DWI, if they see that you have a prior felony.
This is a classic courtroom warning shot. The judge lays it out crystal clear. Mess up your probation, and you're going straight to jail. What's fascinating is how much leverage judges have. They dangle freedom with strict conditions, almost like giving someone just enough rope to see what they'll do. Do you think this tough love approach works?
PCS. You think they're going to treat you good if they smell anything funky? Probably not. So don't give them the ammo to shoot you with a gun. It is a DW, any prior DWI? So the agreement is a DWI education class, one victim impact panel, a TRAS, but you have already done it. So the TRAS here is recommending intensive outpatient treatment followed by supportive outpatient treatment. This is what you must do. If you fail to complete these conditions, I will issue a warrant for your arrest. I will put you in jail and I'm going to bring you right back out in orange and we're going to talk about whether you violated you. And if you do, you're looking at 180 days in jail. Do you understand? No drugs, alcohol, random testing, and a guardian and a lock.
He has, we're going to do the portable because he's not driving, doesn't have a license.
You'll be signing an affidavit today promising us you're not going to drive. Mr. Garcia, do not drive. If you want to see me grow horns and a tail, I'm telling you, don't drive. If you want to drive, do things the right way, ask for permission, get a license, get insurance, and then I will be dancing happily because you're doing things the right way. But if you go out and you do it on your own and you're not licensed, I'm going to lose it. You understand? All right. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send it to this agreement. Good luck to you, sir.
Thank you very much, Judge.
Judge, we have a,
Mr. Garcia?
no,
Okay, all right. Good luck, sir.
Mr. Sullivan, I have Mr. Dixon. For Sullivan, there was a PC.
On Miss Loyola, this is the young lady that a few days ago you took into custody because she picked up a new case while she was out on our bond.
Right, okay.
She had the felony case. The felony's reset. She's here for her, I guess, arraignment on the new bond. But I think you had already modified her bond conditions 2 days ago. So,
Come up, Miss Loyola.
we do need to talk about some driving issues though, Judge. So I'll
She doesn't have a license. That's the issue. If I remember correctly, right?
I think you do have a license.
I was working on getting it fixed. It was not
If you don't have a license and liability insurance in your name, don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
I was
You-
working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive here forth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand? All I'm asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is.
Discovery complete?
I believe it is, Judge. I'm trusting.
Judges, it's, the problem is it's the same transaction out of the felony court, out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try to really hard to find out because she's hoping
Right
that.
here.
Yes.
Mr. Gold is here. That's the lawyer.
Yeah, I saw him today. I
Did you
sent
speak to
him
him? And does he know the,
Yeah.
okay, so I guess he knows the situation.
I tell you right now, Judge, I just better. As far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed because obviously they don't give it to us until the case is closed. But apart from that,
I mean, does that really come in this case anyways?
it can. I mean, so typically the things that would be in there is typically they do an interview with defendant, they do an interview with kids.
I mean, unless it's relevant, I don't know, but.
Yeah.
Um,
I mean, but you are right. I mean, it is a case by case basis.
Can you tell me when that felony's reset to?
Felony is reset to the 21st.
and is there an offer in the felony case?
I believe the note is, I mean, essentially the offer upstairs is that if she takes something on the misdemeanor, then we'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha, 421, Judge?
21, right?
Is there any
I would
way
imagine
we-
that's probably a global offer for everything.
Can we go 422?
Sure.
Okay. That's-
But then she's becoming that day and then the next day. She's on bond.
Right, I got you.
It's up to you.
But hopefully I'll talk to her. If
Yes.
we can get the deal together, then I might just bring her back before then to get it done.
Okay, but after that setting goes clear trial.
I got you.
Got it. All right, John.
Thank you, Judge.